Good morning, friends. Namaskar, Sat Sri Akal, and Adab. This is my 294th video, and this is a classic case. This is a recent judgment of just last month, 2026. And this case is concerned basically of an unauthorized construction. And within that suit, the ownership has been declared. So suit number 159 of 2024, Shrimati Saroj Vyas has fought this case, and she has made the Union of India, Ministry of Defense as a defendant, and the state officer, that is DO Bhopal. She has simultaneously created a pro forma defendant, and that is the Cantonment Executive Officer of Jhansi. Now, what is this case? So, this case was basically on unauthorized construction within this bungalow, number 19 of Jhansi. So, the bungalow owner was issued a notice, or he claims that the department, along with the DO, had visited his bungalow and they were trying to ransack the bungalow. So all this was happening in the month of January 24. So the defendants, or the Union of India, they arrived along with an entire group of people, and they were willing to demolish the entire temporary structure. So this was the basic cause of action. And very honestly, this bungalow owner, under the guidance of Mr. Bakshi, had issued a notice under section 80 of the CPC, which was duly posted on February 15, 2024. This judgment was uploaded by somebody from Jhansi and was even shared with me. I have got the typed judgment, and since I've been admitting since earlier that I'm weak on Hindi, I got this translated into English. And after reading this judgment, I came across the prayer of the plaintiff, the relief of permanent injunction, and a declaratory degree. Plaintiff has been compelled to institute the present suit before this honorable court with the specific prayer that the defendants be restrained by way of a permanent injunction from taking any illegal possession or for carrying out any demolition upon the plaintiff's bungalow in question, or any portion of the land upon which the temporary structure are built, and further that they be restrained from making any malicious attempt to interfere with the plaintiff's peaceful possession and enjoyment of the property. And the plaintiff is even seeking under section 34A of the CPC that his litigation cost be given to him. So we must understand what is the prayer. The prayer is a declaratory suit and injunction, and further he is claiming that he's been in possession of the bungalow. Now, what are the pleadings of the plaintiff? The plaintiff has a word to the effect that she is the owner in possession of the residential bungalow number 19 situated at Hadia Old Grant, having survey number 126, or being called a Khasra number as per the Cantonment Board, and area is about 2.76 acres. Having a bungalow itself occupies 5760.50 square feet or 535.36 square meters. While the temporary structures have been erected in the remaining portion for the purpose of earning a livelihood. So here we must understand the plaintiff is admitting that temporary construction has been done to make an earning or a living. The plaintiff acquired the bungalow in question along with the adjoining property from two individuals, Mr. Vinod Kumar and Deepak Agarwal. They were son of Mr. Motilal Agarwal, somewhere residents, and on 2nd March 2009, the sale deed was registered. Now, this is very important. In 2009, the sale deed. And when did the order of no sale without NOC came. That was in 2011 in the Varanasi judgment of Mr. K.K. Jain. So plaintiff's bungalow and the adjoining property, specifically those delineated in the red mark ABCD annexed with the map, they have no legal right to dismantle the temporary structure or take illegal possession of the property in question. So that means the department was even not only trying to demolish the unauthorized construction, was even taking the possession of this area. Now, this is very important, friend, which I've been always harping on, and I appreciate this. The bungalow owner showed a sale deed of 12th December 1928 through a registered of the same bungalow, which was sold by Jami Munnan to Shrimati Ram Rukhi, the widow of late Lala Jugal Kishore, and physical possession was handed over. Similarly, the property had been acquired and has been in possession since 18th November 1920 through a gift deed to the original owner, Jami Munnan. So Ram Rukhi's son is Motilal, and Motilal's sons are further who sold this bungalow to Mr. Shrimati Vyas. So the property is being in sale deed registered on 333/1966, and subsequently a family partition happened during that period and the share fell to these brothers. All these documents are tendered, so we not get into the details. Now plaintiff has submitted some number of documents which go run down to 11C1, 12C1, 13C1, 14C1, 15. So there is a system of how documents are exhibited in the Jhansi court. So 30C1, 29C is the notice issued under section 248. Certified copy of the GLR is 30C/1/4. There is an inspection report, there is a site plan, schedule paper, there is an order of the court as per 45C1/8. So this order is that of the PP Act, which we will be discussing in the further part. So these many documents, some running down to about 600 or 362 pages is this. Now plaintiff finally, Mr. Brijendra Kumar Vyas, has filed his affidavit, and which is on page 652. So he is speaking on everything what he has said as in his plaint, along with various insertions which he wanted. So he says did not seek any permission from the defense estate officer in 2009 when he purchased this bungalow. It is incorrect that the government is the owner. Fine. It is incorrect that I have carried any unauthorized construction. So here there is a contradiction. He's claiming that he did temporary construction, but here he says he's not done any unauthorized construction. I have no knowledge regarding the inspection on 8th December 2023 by the Cantonment Board or the Defense Estate Office, Bhopal. I have no knowledge of the Cantonment Board issuing me a notice under 245. The notice provided verbal response, then he says. He even claimed that he has no knowledge of the permission of the Cantonment Board is required for the construction within the cantonment. Rather, whatever construction exists in the open area date back to 1928. So these two things do not match with his plaint, with his affidavit. I possess a map of the bungalow in question on 5th August 2025. I received a notice from Cantonment Board under section 248. So, but he claims he doesn't know about 245. I filed an appeal under section 340 to the GOC, which is still pending. I have no knowledge regarding the proceeding initiated to my wife under section 244 of commercial activity. I'm also unaware of any proceedings under mutation section 247 of the cantonment. He claims I'm paying commercial tax of the bungalow, and he's even tendered some receipts. I'm a magistrate and a qualified under PCS Provincial Civil Services. Power of attorney bears dated 24th 12 2025. So I've examined the rejoinder filed by the plaintiff. So that means a rejoinder has been filed, which is 44 oblique C1. So this document becomes very important, which has not been reflected in the judgment to a very extent. So statements recorded in para 7, page number 3 of the evidence of 44 C oblique 2 are correctly stated. However, whatever construction has been undertaken by us falls under the category of temporary construction. And here he claims that there are lot many judgments for temporary construction. They cannot be called building or unauthorized construction. So there are a lot of judgments on this. Regarding the facts recorded in the third line of the bottom of page 15 of the sale deed, which is submitted as 13C2, serial number 1 to 27, paper number 10C oblique 2, it states that the ownership lands of the bungalow land west with the government of India. So this is very important. Here in his sale deed of 2009, it is written that the land belongs to the government and shall continue to vest with this. So the plaintiff now has to counter this, and I appreciate his countering along with the consultant's effort. It is stated that only the structure was transferred, which is factually correct. However, at the time of the sale deed on 2nd March 2009, it was recorded by the registrar's office on the prescribed pro forma with specific words. So he is mentioning some documents, 13C23 of the map, paper C2 on 15, which is attached, temporary construction, 13C23. Notice under PP Act was received from the Defense Estate Officer on 18/7/2024. The said notice was received by me subsequent to the issuance of the stay order. So that means in this case, there was a application on 39 order rule 1 and a stay was already granted before the PP Act notice was received on 18/7/24. So these things are very important. And 15th February 2024, he is issuing a notice under section 20. So here there is a little dispute which he claims in his affidavit that the Defense Estate Officer Bhopal on 9th February 2024 had previously sent the PP Act notice. Means he did not receive this notice. But when did he receive? He received it in July 2024. And during this course of the notice and the other notices on construction, this case has been filed, and on 15th February 2024, he even issues a notice. Within 30 days of the notice, he files this suit. So maybe in March or maybe in April, he gets a stay. So wherein hereby that was fixed for February 22/24, meaning by that the application on order 39 rule 1 is very important in this case. An application for mutation was moved by the plaintiff in the Defense Estate Office. I have no knowledge regarding the inspection done of bungalow number 19, which is his, and was conducted on 8th December 2023 by the whole team of SDOs and cantonment exec. So plaintiff is denying this vital statement, which is on paper as 32C oblique 2. I am however aware that an order of dispossession under the PP Act has been passed against the plaintiff. So when he is filing this affidavit, he is aware that there has been an order in the PP Act section 51B and it is eviction. So the same bungalow owner filed an appeal which number is 72/2024. So what is the status of this appeal? Becomes very important. Now this case is already filed, so we need to know about this case. I do not recall whether a letter bearing reference number BPL 490GS and dated 8th June 2018 was dispatched by the Defense Estate Officer Bhopal. So he is somewhat denying. Similarly, the Cantonment Board, now which is the pro forma defendant, Now, they also are filing a written statement, and they are very clearly submitting and admitting that construction unauthorized or whether or not. So, they are also the bungalow is in the GLR as per government land, various things. Temporary structure has been constructed. 8th December 2023, we did an inspection along with the DO staff. So, various things he is saying, which is quite repeatedly. And there was a notice under section 339. Since the suit is not maintainable, the bungalow in question is situated within the cantonment. So, what is the bungalow owner doing? Instead of filing an appeal, he is going to the court. Further, under section 250, he is barred for filing a suit. A lot many cases have been discussed, and there are judgments which say section 250 does not bar them in filing a suit. Again, claim under 35A of CPC. So now this same performer defendant, which is the Cantonment Executive Board Jhansi, Mr. Ashutosh Verma, is filing an affidavit. So various things he claimed. Anything important which I would like to say, he is very clearly saying that he has not seen the original GLR. Neither did he corroborate with the defense state officer. Regarding the sale deeds of 1920, 1928 or later, he is not aware the defense state officer Bhopal is holding these. He says, I have joined on such and such date, which are quite immaterial. Prior to this, a notice was issued under 244 because this bungalow owner was running a marriage hall in this bungalow. How I do not recall about the notice. An appeal is currently pending in the commander CNC's office under 248. So various things he names, but one has to read through this evidence. He says no appeal was received against this notice. Subsequently, a notice under section 322 of the Cantonment Act was. I have personally examined the GLR as it is maintained. So he is again saying, I have seen an extract, but I have not seen the GLR. So these things quite contradict to the statements given by the Cantonment Board. Now, what is the DO? That is the state officer giving in his paper book. That is 37A1. Ownership as usual as per GLR. 8th December 20, we did the inspection. A letter dated 27 June to the plaintiff asserted she is a public representative. Consequently, people in the vicinity frequently visit, so she needs to make these temporary construction. On February 9, 24, Defense State Officer issued a show cause notice under 5B1, which I am saying, and the notice has been finally taken to its logical end, and the suit is barred again by those things. So what does he say? Again, furthermore, defendant now, DO, which is he's tendering some documents, which is the inspection report, paper book. Now, the following issues, there are some about 11 issues. Whether the plaintiff, based on the vermin set forth in his entitled against the defendant, is a permanent injunction. So this is a very important. So it's noteworthy. I will not talk of this issue first. I'll talk of the second issues. Now, whether the plaintiff, based on his averment, is entitled to a declaratory decree affirming a status as the sole owner and occupant of the unit. Now, this is a very important. Whether in accordance with the written statement, the DO, the right of ownership in the property in question vests with the government of it. So, 2 is for the plaintiff, 3 is whether it is the government the owner. Now, this part of the entire judgment is worth reading and it needs to be piecemealed. Now, what does the court decide on these two issues? The context given, that is establishment, the property in question is noted. So, in all 3 registries, now this is very important, friends. I have been continuously saying, please dig into your land records. So, here there is a gift deed of 18th November 1920, a register sale deed of 12th December 1928. Then further a sale deed of 2nd April 2009. So the bungalow under section 54, section 122 of the TPA Act 1882 and the gift deed under section 54 again very clearly says and provides that the ownership rests with the predecessors and finally the present owner. So the court has accepted these sale deeds. Similarly, in section 122, gift constitutes the rights of ownership. That's very clear. All these sale deeds have not been objected to. Neither the department under section 31 of the Specific Relief Act had ever filed for the cancellation of these registered gift deeds or sale deeds of 1920 and 1928 on the grounds that this was an adverse to the defendant's interest. This fact substantiates the legality and binding of the nature of these documents and does not in any manner affect the rights of the purchaser, as these registered deeds effectively carry the force of public notice and have remained within the due cognizance of the defendant party. Once the plaintiff has submitted this, it is now the burden shifts to the defendants. Very true. To prove whether this is an old grant and what are the terms and the conditions are. So friends, I've been telling in my earlier videos that section 1110 of the Evidence Act is becoming very important here. Why? The onus is to be shifted. Do we prove that we are land? So for this, I have been continuously saying, please do not try and become plaintiff, because if you become the plaintiff, the onus to prove remains on you. But whether can you shift this, which in this judgment, it has been done as per the court. Now the court very clearly says now it is for the defendant. To substantiate the contention, the plaintiff and the owner suit property have filed an extract of GLR, which is 100C1, which again now court says it does not completely say, it just says in column 11, Jugal Kishore or Shrimati Ramrukhi, and further the column 11 that the rights under which Ramrukhi acquired the suit property is designated as old grant. So he's bifurcating these columns 14 of the GLR, and which is very cleverly done, and I appreciate this part of the judgment. Defendants have failed to produce the original GLR. Now here there is a suspicion why the defendants, which was the state officer, did not bring the original GLR in the court. So here when this original GLR is not there on the extract and the columns written therein, the court is not paying reliance on that very judgment. So the documents cannot be proven, the GLR is countered, and now various judgments, which is Purushottam Das Tandon fine of 1984, a recent judgment of Ambala Cantonment, which is in the excised area of Sonmati Agarwal, which finally in Supreme Court has also been won on limitation that the department did not go and argue. So it was dismissed in default. So this judgment of the Punjab and Haryana High Court 2000 upstands. Well, AIR 1935 Lahore very clearly says PT Ankleshwar judgment does not speak much on admission deed, but it does speak on that if the department has to take the possession, they will file a suit in the lower court. In this regard, the court clearly goes on a finding of a Satish Chandra AIR 1927 Calcutta 786. Now in this judgment, the ownership was resting with Mr. Satish Chandra, and he was claiming that even if I am a grant, I should be compensated. So this case was not barely on ownership, it was more on in 1927 on, because in 1927 the GLR did not exist. Friends, we must understand. So this case does not really help on that ground, but it helps on this very factor that land does not transfer by an admission. However, the defendant failed to produce the original GLR whatsoever pertaining to the old grant. So what is the extract 100C1 saying? Nothing. So here the court has indicated very clearly column number 14, because column number 14 speaks of date of expiry of lease. So the court is interpreting whether an old grant is a lease, whether any rent is being paid by the plaintiff on this lease. Are we trying to say that this judgment goes against all those bungalow owners who are on lease with the cantonment? We have to see what we are fighting. So column number 12, 13 and 14 of the sent document does not speak in the significance of proving an old grant. So the predecessors, he says, are been in possession from 1920. More than 100 years. So the court very clearly says whether the applicability of the GGO is there in Jhansi cantonment or not. No evidence has been brought on record. But I would apprehend here something, because there is a judgment of Mr. Hemchand Bhatia which clearly says that the Governor General order is applicable in Jhansi. And the same bungalow has been even resumed under the GGO 179. Now, going into the records of the witness box, Mr. Ashutosh Verma, who was the defendant witness, he hasn't proved the GLR. At the time of the argument, the plaintiff's counsel said on Rule 3 how GLR has to be maintained. So there's a lot of things which could have been done but could not have been done. Now para 27 of the judgment becomes very important, because this page 98/C1 is on admission. Now this is that sale deed of 2009. In this case, Mrs. Vyas's sale deed very clearly on page number 1 and 2, PW1 has testimonized himself that at the bottom of page 13 of the sale deed, paper number 13C2 to 27, which is submitted via list 10C/2, reveals that the land belongs to government and shall continue to vest in the government of India. And he is the owner of the building itself or the structure. So to counter this, the court says, now because there was a registered pro forma and specific words were inscribed on it, and the sale deed was done on those parameters, which was done on 2nd March 2009. So it was not the owner who had any say in making or drafting the sale deed. So here it becomes very important. How is this to be monitored? Because the sale deed is speaking. Now, if you friends understand, 2009, 2025, the pleading of the plaintiff is also simultaneously going to the Specific Relief Act to the government, that did they file a suit to get these deeds cancellation? Vice versa. Understand it. I am here to detail the judgment, not to talk in high or low, to talk on facts. Now, Purushottam Das judgment of 1984 is again rebrushed, which clearly says that Purushottam Das Tandon had shown a sale deed of 1854. And after 70 years, the demand of an admission deed was coming by the government from 1854 to 1837 or 40. So he says, why admission does not transfer title like this? It's fine, but this judgment does not hold, because the court in 2015 threw back this case. That 1984 suit was an interpleader suit. So we need to discuss all this, and we need to see where we are weak on. So paper 74C1/79 clearly reads a letter of the Ministry of Defence 8th August 2003. Well, this letter is rotating. I have a letter of 1927. I have a letter of 1932, further rebrushed later on, and just recently also that how the ministry has been usurping our lands. Very good. This letter was produced and the entire contents of the letter were exhibited and spoken. So this letter clearly says how admission deeds have to be taken. That is why I tell people, if the government is asking for an admission deed, please hold back those letters. Ask them, why are you asking? Here, my counsel could have even raised up an issue called Rule 43, which clearly reads that admission or a deed would be taken when the document of grant is forthcoming. Well, these are nitty-gritties, but it's been fought well. Court pursued these sale deeds and further on what I had earlier already told you. And in none of these sale deeds, the vendor is saying that this is an old grant or the land belongs to government. He's selling that he's selling the land along with building. So the vendor and the vendee, these kind of definitions in the TPA Act are being defined. So nowhere the grantee, the mentioning in the sale deeds or the gift deeds, nowhere such terms are coming as old grant, lease, grantee, lesser, lessee, any rent. So nowhere these documents. So under the TPA Act, the sale deed is conclusive, the court says. So the court has very clearly said on another pleading where on a bifurcation, the department under 51B was looking for the open area or the unauthorized constructed area. So they says 2.76 of the area was sold to me and it is proven under the GLR and as well as the sale deed. So document 74C1/10, letter number B6/19487, the court pursued. This is a letter written way back on 14th June 1934 by a cantonment executive officer to Shrimati Ramrakhi. This is very important. Now here once again, I appreciate, I've been telling bungalow owners, please dig in your records. Please get into the DO's office or the cantonment. Lay hands on every correspondence of yours so that you know what is happening. So here there is an acknowledgement by the cantonment executive officer in 1934 where he is addressing Mrs. Shrimati Ramrakhi as owner of the bungalow. So, well, owner is even said in section 2 of the Cantonment Act 2006 or 1924. So, these things have to be interpreted. Now, another important document which everybody should lay hand in Jhansi, that is 74C1/15. This is the Vazibulas under form number 15M. What does it say? That all lands in the cantonment and this very particular land, which is the khatra number or which is the name of Ram Rukhi is written there. So, this document needs to be verified, proven. But here this document has just been exhibited and spoken in the arguments. Whether the maker of the document has come to the court is a question mark. So this finding therefore on the ownership goes with the plaintiff because of these three sale deeds, non-production of the GLR. So here the court very clearly says, now issue number 1 which it drafted, whether injunction is to be given because of the cause of action. So the court very clearly says when you are declared as owner, your right stands and injunction has to be granted because of your peaceful possession for the past 100 years. Nobody should disturb you. So possession and injunction is a simultaneous thing which the court has interpreted. Whether the suit was barred, undervalued, this is not a material issue. Whether jurisdiction because the PP Act notice was issued, that also the court does not need to interpret because the plaintiff has already gone in an appeal. which has been said by in his affidavit. Now the issue for has already been adjudicated on by the court on 9th January 2026. The presiding officer pertaining to the adjudication on issue number 1 shall be the integral part of that judgment. So this all goes. So here he doesn't say that this issue is against the defendant. So if the plaintiff have been declared owners, PP Act's preamble itself speaks that the PP Act cannot be initiated on me. So here again, the plaintiff or his counsel could have argued on this point. However, the defendant have not emphasized on the reason of non-joinder. It's very interesting. Why the defendant? Because they've been pleading. Because performer defendant of the Cantonment Board does not mount down to anything. Further, the state officer is not a party to this notice. It is the DO. Well, when you claim Union of India by itself, the non-joinder should not have been raised itself. Now, whether under section 39 and 250, there are n number of judgments. So, we really don't need to get into all this. Now, para 10 of the plaint, he's saying what all these saying, lack of cause of action. No, he's now agreed because in January 24, this entire process rose up and these people, the plaintiff was enjoying his possession and the defendants barged into the bungalow for illegal possession and demolition. So finally, friends, this is a beautiful judgment. Once again, we need to understand from this judgment, two things have been countered. One is the GLR, second is the admission deed. Whether the GGO is applicable on Cantonment, Jhansi has not been countering. Whether entire lands in the Cantonment boundary pillars of the notification of Jhansi, whether admission was taken under any law, whether TPA Act is countered by the Grant Act, nothing has been spoken on it. So these are some grey areas in this judgment, but overall, yes, the department will never like to lose on to this judgment. So I believe they would file an appeal on it, and we need to wait what really is the outcome of that and what are the pleadings on that side. So I think this is a nice judgment, and once again, congratulations to the plaintiff and his counsel. Thank you. Good day.